All right, we are going live now on YouTube. So, good afternoon, everyone. This is Devashish Kumar Panda, co-founder, Team Lex Cognoscenti. I welcome you all on behalf of my team to this edition of Lex Cognoscenti's Rendezvous series. So, before I introduce the eminent guest of this evening, I must tell you the purpose behind organizing this series. The basic vision behind this interview series is to facilitate and provide the legal fraternity with some invaluable anecdotes and escapades of several legal luminaries and doyens. And today, fortunately, we are joined by Professor Dr. Anthony Francis Julian. So I welcome you, sir, on board. And before proceeding with the other formalities, I would like to give a brief introduction of our today's honorable speaker. So, Dr. Julian is a senior advocate whose areas of practice are primarily in civil and commercial litigation and in maritime and shipping arbitration. He has been functioning as a maritime arbitrator on the panel of maritime arbitrators in the Indian Council of Arbitration. Having a keen interest in academia, Dr. Julian is also an adjunct professor of law, teaching Admiralty and Maritime Law, International Commercial Arbitration at the Jindal Global Law School of 𝐏𝐫𝐸 Jindal Global University, India, of which he is also one of the founding members and is also in the governing body, Board of Management and the Academic Council. He has been designated as senior advocate in 2006, and since then he has been practicing in Supreme Court and various high courts all across India. He is an expert in dispute resolution, arbitration, and has represented a number of multinational companies and private corporations in India. So I welcome you, sir, on board, and we are really fortunate. We are really obliged to have you today's afternoon, and we are really looking forward to have a great session with you, sir.
Thank you, Debashish. I think you are doing a very good job in this organizing these types of interview for law students and others. It will be very useful, and to get insights from lawyers, especially senior lawyers, for the benefit of the student. So it is very good. I welcome you. I appreciate you, and thank you for inviting me. Okay.
So, sir, I will be taking the first phase of the interview, and then
Okay.
our co-founder, Mr. Jyoti Prakash Datta, will join in, and he will take the other questions that he has with him, and then we'll proceed with vote of thanks, and then we will end the session. So, sir, with
Okay.
your permission, shall I begin with the interview?
Yeah, sure. Well,
Thank you, sir. So, sir, first of all, I would like to know that how was your childhood, how was your family background, and your schooling. So, if you can tell us something on that.
see, my father was a lawyer, and but he was practicing in a district court and subordinate courts. Actually, I grew up in a small town in the southern part of India, in Kanyakumari district, and I went to school, the local government school, and basically my family are all well educated family. They are all most of them are medical professionals. Except my father's, others are most of them are in the field of medicine. But my died, and I was just 11 years old at that time.
Sir, after knowing that, I would like to know that is there someone from your family who is or was in legal profession, and if not, who inspired you to take up law?
As I said, my father was a lawyer himself. He was a successful lawyer, but who was an inspiration for me. I was 11 years then, but then I thought I should become a lawyer. But apart from that, I feel that, or I felt that the legal profession gives a lot of freedom, independence, self-confidence, and you are on your own. So you can build a career on your talents and merits I think that's a real challenge. So I chose to become a lawyer because of that.
After knowing that, sir, we would like to know about your law school and how was your days in your alma mater.
I have many alma maters, if I say so. I studied my LLBL, at that time it's called Bachelor of Law in Madras Law College. It's one of the oldest law colleges. Many judges who were in Supreme Court, they studied in that law college. So I studied RBL. Then I did a master's also there in that law school, or the that law college, and that was the only law college in that at that time in the entire Tamil Nadu state. After that, I also went for a master's in comparative law in Southern Methodist University in US, in Dallas, US. That's a 1 year master's program where I studied a lot about on comparative aspects of different legal systems, different issues, and it was sort of eye-open for me. Then I also did a doctorate in law from Tulane University, New Orleans in US, where I specialized in the area of international finance law. But in Madras also, while I was studying my master's in law, I also started my practice. I was also practicing and attending the master's law course in the evening. Because that time they used to have only evening colleges for master's law. I did my master's in criminal law and torts there, and and it was very interesting. I was practicing. I, I was also studying, and also that gave me a lot of what I would say, insight into the academic aspects, knowledge aspects, how you can, uh, deepen your knowledge in law, so that more and more you know about the different branches of law. It will be, useful for you and for others.
That's quite interesting to know, sir. And also, as you said that you have done your masters from SMU, Redmond Law School of Law, and then your doctorate in Tulane University Law School. So I would like you to tell our viewers, inform our viewers as to how we can enroll in those colleges and what are the criteria that we shall see or we shall checklist before going to those law colleges.
See, one important thing, which the foreign universities look from you is your grades in your undergraduate law degree, that LLB, so that they select you on that basis. Like I was a university rank holder in my. What I was saying about foreign law school. See, so they look at from a overall perspective. They see your what they call statement of purpose of studying higher education or higher law course in US, and what your future aspirations. Why do you want to undertake such a advanced study and all they look at. So this is basically they assess you from different perspectives, so that they get a good student, with a dedicated dedicated purpose to undertake higher studies in law. That's what generally they look at. But it's not very difficult. Only thing is you have to relentlessly pursue that you want to study law, because when I applied in 1980, there was not many opportunities like it is now. Now there are so many law schools in different countries. Even US also, there in USA also there are so many law schools. They are offering master's program in different subjects. So I think it's good for one to pursue higher study in a foreign law school, whichever may be the country. where you learn a different under a different system, and also it will be useful. It will give you a different perspective in your knowledge level.
Now, sir, as we know that know about your schooling and then law school days, your master's, doctorate, and all, I would like to know that in which year you enrolled yourself in the bar, and how are your initial days at the bar?
I enrolled in the year 1975, 47 years ago. At those time, those days, see, if you look at the legal profession mainly consisted of litigation. You have to be a litigation lawyer to be known as a practicing law. Well, there were very few law firms. Now what you see, these multinational law firms are even, because transactional work for lawyers was very, very less. So most of the lawyers, once they study law, they start, practicing law in the courts, basically litigation side. So that was the main type of practice. So basically, you have to join under a senior, under whom you get initial training, and learn how to argue before the court, how to face the judge. That's very important. See, when you come out as a law graduate, you have less idea about the actual practical side. Yes, unlike now. Now since I'm an adjunct professor, I know what's the system of teaching of law. There were no moot courts, there were no internships. You join and you finish, come out after 3 years. You know only about the academic side, what you learn in the classes, and of course what you learn in your law school is not much. It's totally different from the actual practice of law. Unlike now, law students, they take internships while they also study in the law school, so they have got an idea about the practice, but still it's very minimal.
All right, sir. Uh, Now, as you have said about your initial days at the bar, I would also like to know that as you are a second generation lawyer, so you must have faced your set of challenges. So, what were your challenges being a young lawyer at your time when you joined the bar?
Yeah, as I said, when my father passed away, I was just 11 years. So, I had the benefit of seeing his books, law books at home, and not much about, knowledge about his role as a lawyer. Of course, he was a successful lawyer even at that young age. But then, that motivation or whatever inspiration was there. I started my practice in the High Court Madras. It's like appellate side. So not much of a trial side, but I had done trial work also in the lower courts, but mostly appellate side. See, basic thing is when you just come out of law school and when you join the profession, first thing is that you won't have any clients. Clients won't come to you, because they clients always look for success. For success, they look for known lawyers, or lawyers who can uh, deliver them the success in their case. So you have to basically work under a senior. In those days, it was much more. It was like never like a gurukul. You have to be very loyal to your senior lawyer who have I may add about my senior also had 4 or 5 juniors, but there are lawyers who had 20, 30 lawyers. So that means you have to wait for your chance patiently, but at the same time, you cannot, ignore the work, the preparation. So basically, the challenge is you have to prepare a case, brief your senior, and you may have no opportunity to even, present a case before the court. And of course, if you are in a big law or under a senior, your salary or remuneration would also be very low. That means you basically work without any salary or any pay. So that's one thing, but then you have to work. That was the challenge. You need a lot of patience. Patience is very important. Dedication. When you see your other friends who chose other professions, they were earning well and well settled in life. At the same time, you are a struggling person. You are a young lawyer struggling. At the same time, working hard. But you will have to face those situations. But then, suddenly things will change. That happened to me, things started changing. Then, that's how the challenge. Nowadays, it's different. If you compare now, I know in Jindal Global Law School, students just they pass out and they join, law firms, starting in, six-figure salaries. And, some also hired by, some law firms for the maybe on the transaction side, but even litigation, they are paid well. Or even you join as a intern with a lawyer, law firm, or a judge, your basic needs are taken care of. Those days it was not so.
Indeed, sir. So, sir, after knowing all these, I would like to know that how was your experience in appearing in the first case of yours in which you have argued, whether you were nervous or what kind of feeling you had, if you can tell something.
See, always the nervousness is there, but then, the thing is, how you don't succumb to it, how do you have to overcome it? Well, that's you. If you succumb to the nervousness or, you may be like they say butterflies, You take the example of Mahatma Gandhi, first case he ran away from the court. So, this is part of the profession, part of learning. And so I had been as a junior those days, junior lawyer. His first work in the court is to ask for passovers and adjournments, so that your senior case is called, your senior is not there. Even that's happening in the Supreme Court also now. The junior will go and ask for a passover. Sometimes, the judge will be kind, he will pass over. Some judges deliberately try to, poke at the junior who tries to ask for a passover. So even for asking for a passover, you have to be somewhat prepared to answer judge's question. But so first case, which I argued was very interesting in the sense, it was a sudden, unexpected, offer came from my senior. So I just came back, I think that day from holidays, and I just went and met him in the court. Then he asked me, "Are you ready to argue a case?" So I, I didn't want to say no because it was like my dignity and self-confidence. I said I will. So that case, this was at around 10 o'clock in the morning. That case was lower down, and it would reach at after post lunch. And the judge was one of the most difficult but brilliant judges in the Madras High Court at those days. I think it was in 1976. And he was very sharp-witted, very sharp. And the lawyer, if a lawyer goes without preparation, he'll find out. If you tell a fact, wrongly, he will catch you. Is that right? Very shrewd. He will read the brief and come. And his name was Muhammad Ismail. it's a terror like, you know. So then only I looked at the judge. It was he. Maybe my senior just thought, you know, wanted to, you know, test my, you know, capacity. So I then prepared the case. I was for the appellant, you know, so I have to argue, open the argument. So I went around maybe around 2:30. The case reached. I went there and I sat, you know, very confident. So then he asked me, called me, what's the case? So I started telling the fact because I took care that I would state any facts wrongly. I was very careful, so I noted down. So I just, you know, 5 minutes in because he had already read the brief. He knew very sharply. So immediately asked me to sit. And I asked the other side, what do you say for this point? So, you know, he couldn't really meet that point, you know, it's a question of law. He said, no, I won't agree. So in 10 minutes, the matter was over. He decided the case in my favor, you know. It was a real, you know, very surprising success, you know. I never expected that that day I would argue my first case before a very difficult judge and succeed like that in 10 minutes, you know.
That was quite interesting to know, sir, as to how you got breakthrough in a case in which you were not expecting to get one. So
Yeah.
that was quite interesting, sir. Now, sir, as we know that you are an expert in arbitration, maritime law, admiralty, and alternative dispute resolution side and civil side. So there must be n number of cases that you have dealt till now in almost more than 4 decades. So we would like to know that is there any case which is really closer to your heart, and you would like to mention any anecdote or any point of law or anything related to those cases that will inspire our generation in particular.
See, there are two aspects, you know, in terms of when I say arbitration. When you say arbitration today, it's well known. But when I studied, I didn't even study arbitration law. But when I went to US, I had taken on course on arbitration. But still, I didn't have much. But after I came back, you know, I returned to India in 1985 after 4 years abroad. Then that time, you know, arbitration was just emerging as a new branches of practicing. So I was advising some public sector undertakings like Food Corporation of India and, you know, some other, you know, PSUs where they engaged me to handle their Admiralty matters, maritime matters, because Food Corporation was one of the biggest importer at that time, food items, sugar, etc. So they didn't know really how to handle these matters. I have also studied Admiralty in University. See, what I did basically in my master's, the law degree, there was I took courses which were normally not available in India in those days, which, you know, I thought it's an opportunity to know. So these courses like Admiralty I studied, arbitration I studied. So I was able to advise, you know, these public sector undertaking on these type of cases. You know, there are high stakes were involved and issues were very complicated. They are basically international commercial arbitration matters. So that gave me a grip, you know, on, you know, how to do these matters. And also then, you know, when the awards were challenged in the High Court, I used to do that. I used to conduct several cases before the arbitrators, before the High Court and the Supreme Court. So, you know, that was that, all these things, you know, very unique experience because in an emerging field, I was able to contribute, you know, for, you know, various things. There are many things I can say, but one thing, the experience as a lawyer practicing in a court is different from conducting an arbitration cases before an arbitration tribunal because see the setup is different. In the court you have the aura of the court, you know, judges, all that thing. But here it's quite informal, and you know then you should know also how to handle the arbitrators who may not be judges many times. So, there are different experience. Now I am myself an arbitrator. I am an arbitrator. I have also sat in arbitrations. So, even that also gives me a different idea about, how to be an arbitrator. So it's very, very unique experience, I can say. There are specific cases, involving huge stakes, which I had fought in, like fought in before the arbitration tribunal, before the High Court, before the Supreme Court. There are many cases are there which, I cannot specify that this is, there are already very interesting experience, I would say.
Absolutely, sir. Sir, as we are discussing about your experience in arbitration and connected laws, I would like to know, or I would rather say, or request you to give advice to young law and legal professionals or law students as to how to go about with reading or adhering to the arbitration law or alternative dispute resolution methods. So, is there a few brief tricks or pointers that you can give to us?
See, specifically an arbitration, it's a very fast changing, field of law. Because I say when 1885, when 1985, I started in this area, there was not many cases, not known. The act was different. There was an arbitration act of by 1940, which was very old and all. Then 1996, the new act came and it changed the whole dimensions of arbitration. And also, the once the legal system covering arbitration changed, then also the role of lawyers also became more and more challenging in the sense more and more specialized. Today we are in international commercial arbitration. I've been teaching international commercial arbitration since 2005. Uh, so from 2005 today, if you look at it's a tremendous thing. Even today, I'm teaching international commercial arbitration as an adjunct professor. So, but the law is very fast changing. International commercial arbitration is something every year new decisions coming, new legal principles are laid down. A lawyer has to be, I would say, I tell my students also that you have to be good comparative lawyer, you have to be a good conflict of law lawyer, so that you should be able to understand the intricacies in different systems of law. Because in the international commercial arbitration is deals with different systems of law in one case. So if you want to be a successful international commercial lawyer, even arbitration lawyer, you should have the ability to present your points across that arbitration tribunal in a very convincing manner. Unlike in a court, because you don't have that what that court setup is not there here. It's quite informal, but at the same time, the lawyer should be able to take advantage of that. You should be able to argue. You should be a good trial lawyer also, because most of the time when you conduct an arbitration, proceedings, so for an arbitration tribunal, you should know the procedural aspect also, and so that you should know how to examine a witness, how to present a case. But it's different because CPC, Code of Civil Procedure, doesn't apply. Indian Evidence Act don't apply. So you should be able to take advantage of that, and you should be at the same time able to prevent the other side from not taking advantage of that. So it's a very interesting, but at the same time challenging and very rewarding also.
Undoubtedly, sir. Uh, so, sir, as we have dealt all these aspects, after that, I would like to know about your seniors. As we know that you have worked with Mr. S. Padmanabhan and then Mr. UNR Rao in Chennai.
Yes.
So, I would like to know any peculiar fact about them that you would like to mention our viewers, and about any other seniors at your time, if you have come across with them, or if you have worked with them, so you can tell about some of your seniors, so that we can know that okay, these were the doyens of the bar at that time, both at state and national level, you can say that.
See, Mr. Padmanabhan, with whom I started my practice, was a very good, well-known civil lawyer, and in 3 years he became a judge at the High Court, and he retired as judge of the Madras High Court. But he was very particular in that I should learn civil law and also learn how to prepare a case, because preparing a case is very important. Mostly, the appellate side, then you should have you should read all the lower court decisions, the evidence, because and the documents. So you have to really do a thorough exercise on all these aspects. You can't just ignore. Then on facts you have to be very thorough. Then you have to prepare the law. See, facts and the relevant law you have to prepare. Then only I could brief him, and so that so he was very strict on that. You he will ask. He's not somebody who will harass you. Morning he will ask, okay, which case is the today, which case is tomorrow. Then he will ask me, tell me something about what is the key point in that, and what's the argument. If you haven't read, then you won't be able to answer. So he will judge you by that. And as a very dedicated lawyer, I didn't want to show, yeah, that I was not prepared. So be I used to be prepared, well prepared, whenever, he asked me about a case. This is one thing I learned from him, how to prepare a case and, present a case. And about Mr. Yuvan Rao, he was a different person in the sense he was at that time there was no additional assistant solicitor general in the High Court. Only the senior central government standing counsel was the lawyer who handled all central government cases in the High Courts. He was a senior standing counsel in the Madras High Court. So he used to have a lot of government cases. At those days, there will be only 2 or 3 senior standing counsel. So he was the senior most in that. So I used to have lot of cases from different branches of law, central government, customs, central excise, foreign exchange, other, um, detention laws, all kinds of cases. So one thing is, so he didn't have much time to prepare a case because he had so much, so many. So I used to prepare all those cases thoroughly, and I used to brief him. That was a very challenging and testing time for me. But he provided me the opportunity to learn different branches of law, which I didn't have it before, like central excise, customs, foreign exchange. So these were all, very specialized branch of law. So actually that these experiences, equipped me to handle any case in, when I later years in Supreme Court, I had to handle cases, I could do that.
All right, sir. So as we now know about the doyens of the bar of whom you have mentioned now. Now you would like to know the legends of the bench at your time when you started practicing, maybe in Madras High Court, or when you shifted to Delhi in the Supreme Court. Any instance with them you would like to mention us, so that we can treasure those things which which we couldn't witness on our own.
No, those days, there were like our present Attorney General, he was practicing there when I started in 1975. And he was a very successful lawyer at that time, also in Madras High Court. Then, Mr. Parasaran, whom I think was former Attorney General, He was also practicing there at that time. And there are many others who later came to Supreme Court. Uh, the 𝐏𝐫𝐸𝐻𝐫 Ramasamy, who also became an Attorney General here, he is no more now. So they all, had their practice there. And Mr. P. Chidambaram, he was also, uh, uh, he was a junior lawyer at that time. So many people, who started their career in Madras High Court are very successful. They continue to be successful. They are here now, and they are also very successful here. So that practice which they developed there, which stayed throughout their life, and they stay with them now also. So that is something remarkable. So, and also some also see some of my colleagues also, like my who studied law with me, they later came to Supreme Court and retired as Supreme Court judges also. So see the time has changed, and people also they come and go, and some stay. So they are all wonderful experience. When I see my the person who studied law with me sitting as a Supreme Court judge here and arguing a case, it's a very interesting experience. I will say interesting, but that's what it is. So whom you know face to face very well as a young lawyer.
All right, sir. So as I have completed the set of questions that I had with me, I would
Okay.
request Jyoti Prakash to come to the studio, and he will be
Okay.
asking the questions that he has with him in the second
Okay.
part of this particular interview.
Okay,
So I would
Debashis,
request,
thank you.
thank you so much, sir, for answering so
Okay, okay,
lucidly.
okay,
And I would
okay.
request all our viewers to stay tuned with us. This part will be an interesting and enlightening one. So, Jyoti Prakash, please continue.
Thank you, Devasis. Good afternoon, sir. I was
Hello,
listening
good
to all
afternoon,
your
Jyoti.
answers. Thank you,
Yes.
sir. Thank you.
Okay.
I was listening to all of your answers. They were very frank and lucid, as well as you were very candid while answering all those questions. And that was a delight to listen to you, sir. And, sir, with your
Thank you.
permission, may I begin the second question?
Sure, please.
Thank you, sir. Sir, as we have dealt with many aspects of your life and career, now I want to know what are the most important cases that you have dealt with till date.
Different cases, you mean, right? You asked different cases, isn't it?
So the important and landmark cases. Otherwise, you can also say the cases which are very close to your heart.
See, one case I can say, because see that was a very unique case. There are so many cases in different branches of law, but one case, it was really very challenging for me, which I in Supreme Court. Say there was a dispute on seniority between the lowest, judiciary in Tamil Nadu. That is between directly selected district municips, around 120 of them, and promoted as district municip from magistrate, second class magistrate. They are around 200 and all. So what these direct recruitees are who are recruited later. Then those this magistrate, second class magistrate, who were already in service. So when they fix senior, when they actually merged, these two cadres, the issue arose which set should be senior, put in the first, and so that it will have effect there in their promotional chances. So I was representing the directly recruited district magistrates and around 120 of them. So they had succeeded in the High Court, and then the other side had filed a specially petition in the Supreme Court. So we had filed caveat, and the matter came it was heard by the Chief Justice of India at that time. So he heard it because he didn't issue notice and he reserved orders. So because there were many other parties also, like government, the High Court and all. But then the order was reserved. Then almost after about 2 years, just before the day of his retirement, the matter was shown for orders. So to our shock, the matter was allowed against our claims. So it was, really devastating, because these affected people, they were, really complaining. They say, see, no notice was issued. Many other respondents, and what to do, and this is the final court of a court, and what is the remedy? There's no appeal. No. So I was also very reluctant, and I thought one thing, I consulted with other senior lawyers also. Then I decided, to file Article 32 petition. That's a writ petition challenging the judgment itself. So that was almost first time, you are challenging a Supreme Court judgment in the Supreme Court. Our main ground was, violation of principles of natural justice. No opportunity was given to all and all. We are very skeptic, but we'll take because no other way to get out. But our chance, the Supreme Court admitted the matter, and eventually they allowed the matter. So that was a very unique experience of filing a writ petition challenging the Supreme Court judgment itself.
That is very interesting, sir, to know from you that story. And sir, after that, as we know that you were a senior advocate, you were designated in the year 2006, and before that you acted as an advocate for years. So, sir, it is known to us that senior advocates are not allowed to accept risks directly from their clients. So, when you were designated, you must have some problems as to what you would have done to your briefs that you possessed that time. Because after being designated, you cannot deal with those briefs directly. So, what did
Yeah.
you do at that time?
No, I passed on the matters to my juniors. At that time, I had juniors with me. So I gave all those matters to them to deal with things. That's what normally everyone, every advocate who has been or who is designated as a senior advocate, he will pass on the brief to his office. Normally, by the time you become an advocate, who will be eligible to be designated senior, you have, juniors in your office. So basically they handle the matter thereafter. So that's what happened in my case also.
Okay, sir. And sir, after that, as we know, you are an adjunct faculty in the OPG in the law school. So, how you managed to act both as a professor and as well as a senior advocate in the Supreme Court of India? How you managed to balance between both these professions?
Yeah, actually, before started in the Jindal Global Law School, I was teaching part time in the Indian Law Institute. I was teaching for LLM students there, international commercial arbitration and Admiralty. But that classes used to be from 4 to 6, so that it didn't clash with my court appearance. Same also I did in Jindal Law School, even I'm doing now. I only teach 2 credit course there that on once a week, and the timing is 5 to 7. So after I finish my court work, may take an hour and a half to reach there. So normally I'll be free before 4. So I plan schedule. If there is some cases, which go even after, I'll just go up to 4 o'clock. then I would tell the students just wait half an hour more and then I teach. So it never clashed with my practice in the course. And also, it also gave me a lot of insight, on the branch of law which I was teaching. I prepare myself. I know the development, on that branch of law, which normally when you practice in the court, you will know only with that, focused knowledge, with regard to that particular case only. But when you are a teacher, you will have an overall perspective about that subject.
Indeed, sir, that's true. When we are a teacher, then we will have overall perspective over a particular subject of law. And sir,
Yes.
after that, as we know that you have contributed in drafting of several legislations, and you have also drafted so many cases for your cases. So you have a rich experience in drafting. So could you please share us some experiences and some pointers as to how to draft several petitions and applications, and after that also shed some light on how to draft legislations in particular.
Yeah. See, drafting, actually, there is a skill you learn, you acquire, and by learning and practicing. See, most important aspect is the word you use, especially like when you study. The words are very important in law, so that the meaning conveyed by a word, even an adjective or adverb or pronoun, how you do it, what you want. As you know, even a comma is important. So basically the thing is you should have a good grasp on the language. So what word you'll convey, the right meaning you want to convey. So that's one important in any drafting. Whether you see drafting, I would say pleadings. Pleading is for the lowest court, or the where you spell out your case. Whether you draft a plain written statement, or in an arbitration matter you write your plain statement or reply. These are all. This is one type of steps. You also draft submissions, legal submissions before a court. So that is a different approach. So are you draft grounds of appeal when you file an appeal, or you file even a drafting SLP in Supreme Court? That's a different aspect. Then overall, when you have to draft a statute, that's a different experience. So when you look at it, if you are, for example, if I start with drafting a pleading, if you are a plaintiff or defendant, see, basically, Code of Civil Procedure itself prescribes the format. The basic thing is you only state the facts, no argument, no law. You state the facts, very crisply, and don't put unwanted words. See, because any time if you put unwanted words or sentences anywhere, that will lead to trouble only. So avoid that. Put precisely, succinctly what you want to state. This is a basic rule of drafting pleadings. But when you come to appeals and when you draft SLPs, then you have to in appeals also you can't confine yourself to facts alone. You have to also say the grounds how the decision of the lower court is wrong on fact and on law. So there you have much more, but you have to do that. If you don't do that, then you have not raised all grounds available. Then when you come to drafting itself, it's a different altogether, because there the ground is different. Supreme Court looks at your SLP, especially petition from a broader perspective. How basically, if you can show, even if the lower court has not committed an error on fact and law, but the overall decision has resulted in injustice, or it has laid down some wrong principle of law, that you can raise there. Supreme Court law, highest forum, but has unlimited jurisdiction. So what I am saying, the way, you're drafting, there is no uniform rule applicable to all sorts of drafting. Or if you are drafting your submissions for the court, because arguments are over and you submit or to the arbitration tribunal, then you have to deal with fact and law, everything. And that's your argument. So that's a different one. Then you come to statutes, then you have to be very, very careful because there you don't have much leverage. First of all, you have to follow a pattern. It's already there because it's scrutinized by the government, the law department, legislative drafting. Already they are there, very experts, but you draft a model law, give it to them. So they look at it, they are scrutinized. Then it goes to the legislature, whether it's a state assembly or a parliament, they scrutinize. So it's so many processes involved. So, their only thing is most of the time they may not accept your final drafting. They make changes. But then you always have to be careful in what you state, what you what you want, what you intend, the law to be. And you have of course advantage of books and also earlier statutes which will give you an idea about how to put words, sentences there.
Right, sir. So thanks for giving so many pointers and giving us the way as to how we will adapt, and all the younger members of the bar who are watching this video will get some inspiration and knowledge about drafting. And sir,
Okay.
after that, we want to know, yes, sir. Sir, we want to know something about oral advocacy. What are the most important skills that one should possess to be a very good oral advocate, especially in the higher courts like high courts and supreme courts, supreme court? Yes.
See, in my view, see, most important, basic, part of any oral advocacy is you should be thorough on your case. So if you are not thorough on the facts and law, you cannot present your case. Basically, oral advocacy is how do you present your case. So the basic thing is you should be prepared. You want to give a good food to your guest or whoever it is, you should prepare it well. So preparation is fundamentally. Many times, if you are not ready, you have to argue, unless then that hesitation is there. You feel, there. But if you are thorough on facts, that confidence is first. Second is, how you present yourself, present the facts and the law. So this also is also, that you gain by practice, because see, oratorial skill is not necessary for advocate, or advocacy is different. Maybe a good orator. I've seen many good orators, also lawyers. They come and appear in courts and they make a fool of themselves in court. I have seen that. So it's not oratorial skills. It's your legal skill is different totally. So you have to then you have to be thorough with that. Then most important aspect is here you are not addressing the public like in an orator or a meeting or a political meeting. You have to convince the person to whom you are addressing. You are addressing to a one judge or two judges or five judges or maybe more. So, but so your skill or your advocacy skill should be addressed to those people who are sitting as a judge. So their reactions. So if they ask you a question, if you don't answer, either you don't know or you are not prepared, then they will get a bad impression about you, which is not good, ultimately for the success of a case. So most important is, so you address the court, not anybody else. And fourth, I would say is how you deal with the arguments of the other side. So in my personal view, I would say it's not big, oratorial skill in that sense. There may be some lawyers, who are good at both. They can present the case very well. They have that skill, all these things. So that's also, but I would say that may not be necessary always.
Absolutely, sir. And sir, after that, as we know, in the recent times, after the advent of national law schools and the private universities, there are several moot court competitions, trial advocacy competitions. So, do you feel all these competitions are helping to create some skills or inculcate some skills in the young legal professionals?
Definitely, because you have a sort of practice. As a student itself, you know how to argue a case. I have presided few moot courts, and also I have seen how the students prepare their cases, arguments, which are really good. Sometimes they are much better than when you prepare a case for appearing in courts. Maybe the environment is different. From a court and a school classroom in a moot court system. Because that pressure of success may not be there. Like here, you are answerable to a client. Because if you lose his case, he will always. He will come and ask you, question you or challenge you. But here, but definitely the way they prepare very well. Some of my students also come to me like in arbitration matters or Admiralty matters. They have moot courts and they want me to help them preparing it. See, it's very, I really used to admire them, they go so deep into the point and work out. They are very good, they are very good.
Indeed, sir. The mode of research is also very modern. Nowadays, people use
Yeah.
SEC Online or Manupatra, these kind of tools. And all these tools would not have been there in your time. And these tools are really helping students like me and Devasys to participate in good competitions. And it is
The-
the research is done in very easy manner. Indeed, sir.
That's right.
And
Yeah,
sir, after that, yes, sir. And after that, sir, we want to know what are the most important reforms you want to see in our legal system, especially in the judiciary and also in the legal profession.
changes you mean? Changes.
Yes, yes,
See, one problem which all of us know is the case the delay in backlog of cases. Like that's one common problem which is faced not only in India and also sometimes in other advanced countries like UK, USA also. Backlogs are a problem, but here it's much more problem because the number of cases and number of judges, more number of cases, less percentage of judges. So that may be, so that's a very serious problem. So that changes the perspective of the justice system, how fast, because speed is very important. If you have to wait for justice for a long time, then one loses faith in that because I think that's the approach of many uh, clients who got a favorable order or who anticipate that he has a losing case. He will be happy, that it as long as postpone as long as. So I remember one case in Supreme Court. It started in 1935, and I was doing it in 1959, 2015. So even the judge was asking me, "You are fighting this case for so long?" I said, what to do? The clients don't, cooperate. I tell them to settle. Then he told me, no, I won't permit this to happen. You settle. I'll give you, 1 month. You settle them. Then the other side also. Then he pursued the client. Say you settle or you lose the case. So we settled. The matter was settled after how many years? Almost 65 years. So that day, next day in the paper also it came. Some 70 years dispute settled in Supreme Court. What I'm saying, See, delay is the most important problem. So delay also has implications on the parties, on the lawyers. Then I think that's the main thing. But others they say you reduce the time given for a case in the court for argument, whereas lengthy arguments are permitted, and adjournments are given quite often. Lawyers tend to charge huge fees. Their interest is not in justice but in making. See, all these general allegations are there, but again, they all have to be appreciated on each situation. See, there is no general problem to change.
Indeed, sir. All these problems are prevailing. And as you very rightly pointed out, that pendency is the most important problem. And we have to deal with that very seriously. And there are 3 crores, more than 3 crore cases pending in all the courts of India. And it is a very serious problem. That's quite right, sir. And sir, after that,
Yes,
as we know, you are faculty in the OP Jindal Global University, and you are also an advisory member to several private universities. So you have seen the education system in India very closely. So what are your advices for reformation in Indian legal education system?
now, as I said, when I started in 1972, I started my legal education, and now looking at it, now how many years? I think 2004, more than 50 years. See, there is tremendous changes and tremendous progress, and Indian law schools are trying to match, our progress in the educational system, especially legal education system, as in other Western countries like in US, UK. Actually, that was one of the purpose to start Jindal Global Law School. When I studied law in US almost 4 years, now for 5 years. Then here, I have almost like 8, 9 years legal education. So, and I had the opportunity to compare both systems. I think, those days, it's like, the focus on, teaching, learning, and preparing a lawyer was very minimal. So now we have progressed a lot, and we have, much, a better way of teaching law in schools. But one thing, which I still found lacking in Indian legal education is, opportunity for the students to learn different branches of law. And even today, like, when I that was one thing I did in US in my master's degree, or other classes I attended. I took an opportunity. I took an op, like that opportunity to learn branches of law, which you can at that time it's not taught in Indian law schools, like Admiralty, conflict of laws, comparative laws. They used to those. I'm talking of 82, 83, and uh, other branches of law, like they used to have economic law, so many type branches of law those days. But those laws, those branches are even not yet taught in India law schools. So even Admiralty law, I took upon the task to teach Admiralty law because of that. Because not many law schools are offering that course today. There are so many law schools. They even offer LLM in Admiralty or Maritime law. We don't have. We have so many ports. We have such a vast sea coast. India has been a sea power for so many years, centuries. But still, that law is very less developed. That is one thing I find, very, very, even very sad, in Indian law school. Students should have opportunity to learn any branch of law, comparative, income tax, global taxation, comparative conflict of law. See, I attended one course, comparative conflict of laws, which even conflict of law is not taught as a course here in a very maybe one or few law schools it is taught. Intellectual property, various aspects. So, those are something we are into. Similarly, also judges you take, we need specialized judges, judges who understand different branches. I have handled many Admiralty cases, maritime cases. When it comes to court, I have to, argue first, how educating the court, on that branch. That only, we have, now sometimes, some way this specialized judges are there, but it has to be more and more at the lowest level of judiciary.
Undoubtedly, sir. There are several rising areas of law, and we have to explore all those areas. And we have to give best of the faculties to students to learn all about those laws, because those are promising and rising each day. That's quite right, sir. And it is very
Yeah.
fortunate to you that you are also teaching in a private university. A experienced and senior advocate like you, acting as faculty, is really a fortune for all the students who are learning from you. And it should be also permitted in government law schools. Senior advocates must visit government law schools to teach law, and that would give some practical knowledge and theories, practical aspects of law to our students. And that's quite right, sir. And sir, after that, as we know, you are also a resource person to National Judicial Academy, Bhopal. So, do you feel there is some lacuna in teaching system or in the training system of our judges? And do you think any reform or any addition should be made to the training system to the young judges?
No, actually, I was not there now. I was there for 3 years. I was acting as a judicial, sorry, resource person for. See, lower district judges used to come and high court judges also used to come. And, basically they focus on branches of, of law which are developing. Like I tell you my experience, one day I was conducting a, uh, not course means, it's only a lecture, maybe a 1 hour, 2 hours lecture. So I was talking about arbitration. Imagine it. I said about arbitration entry. That time it's judiciary, especially the lower judiciary was not very much I think aware of. I don't know, but so I told them about the awards and how awards should be challenged, etc., etc. What are the possible issues would arise, etc. So that was in one session. Then I went again. No, then in another session, maybe after 3 months or so, another batch of judges came, district judges. So the one judge who was district judge in a northern state, I don't know which state. So he, after I finished, he stood up and said, "Sir, in last class, last your talk, you told me about the arbitration law and how to deal with that. What all the issues." So I then understood it. There was one matter pending for almost 7, 8 years in my court. I went and disposed of the matter after hearing you. So that is why I'm saying this example is because that's how because judges, especially lower judiciary judges, because district level may not be familiar with developing areas or specialized areas, branches, or less opportunity to learn. No, like if you look at arbitration law, an award can be challenged even in a district court. So then they should be very much familiar with the arbitration law. So that's why this judicial academy, this that helps them to upgrade their knowledge, to be familiar with the developing branches of law. That way it is good.
Indeed, sir. Very right. And sir, as we have dealt with many aspects of your life and your legal career, your career as a legal academician, I will now like to know from you something about your personal life. So, what are your hobbies and what are your pastime activities? What you prefer to do when you have nothing to do?
See, I always make myself like, I never uh, had any situation where I had nothing to do. Because I always believe, lawyer plus. You should be a lawyer plus. This plus means many things, because many people, some people become politicians, and we like, many out of our senior lawyers are also MPs, members of parliament. That's one thing, and the ministers, etc. So they are socially active. But this that is one aspect, like our freedom fighters, Mahatma Gandhi, Jawaharlal Nehru, many other, they were lawyers, but then they exclusively became freedom fighters. But today's world, I think you have plenty of opportunity to contribute as a lawyer for the society. That is this plus. One is, as I said, an academician, and also, I'm an arbitrator myself. So, at this academic and my association with legal education, or the education generally is one plus. It, but apart from that, I actively play a role in social service activities. Like I used to organize legal literacy camps where you educate people at the lowest level on rights, because rights of women, rights of tribals, rights, because when you interact with them, you know that they don't know anything about criminal law. They don't know anything about you are right. They don't know the difference between arrest and the bail. Like, fundamental things they didn't know. So that was one of my, occupations which I did. I have a foundation, through which I do a lot of healthcare awareness programs. Like my other family members are doctors, so we conduct medical camps to create awareness on different types of different types of health problems, cancer, and then diabetes, blood pressure, blood donation camps, many things we do. And another also on destruction of environment, like I find there's a large scale destruction of mountains, rocks, like in Western Ghats from where I come from, they break the mountain for the purpose of building harbors, because those rocks, they are mountains, they are very old ancient mountains, are being broken down by Western interests. So we fight, create awareness among, people, so that, this environmental degradation would be put to an end. I think the lawyers can play a much better role. I used to go and address, district court bars or local bars when new statutes are enacted. Like when Right to Information Act was passed, I gave a series of lectures on the significance of this Right to Information Act, because they should be aware. The lowest court and people there should know how to exercise their rights, how to get information. They didn't know that information is their right. Similarly, also other new acts come. I make it an opportunity to go and address the lawyer courts, lawyers, their bar associates. So I think this plus has many angles, many dimensions, which I do. I happily, and also now also I'm writing, apart from what I have written, I'm writing a book on Admiralty law. So that also keeps me busy.
That's quite motivating, sir. You do so much social activities, and especially you said the people from grassroots should be informed about their rights. because if they are not informed about their rights, then all these legislations are of no use. You are doing a very great job by informing them their rights and also providing several lectures as to how they can exercise their rights and how can they approach courts to enforce their rights. Those are very noble jobs, sir.
Yeah,
And
actually I prepared a booklet, our laws actually, in vernacular, in Tamil language. So I used to go and talk to these, women self-help groups, the women organized at lowest grassroots level, and gave them these booklets, different branches like marriage, divorce, labor, labor in the sense, employees, workmen's rights. They are exploited, by the employer. That's very. Then also I was part of a development finance, international development finance organization based in Netherlands. I was their board member for 6 years. I have extensively traveled all over the world, many poor countries in Africa, South America, Asia. I visited deep villages there, and seeing them, how they make their life. So it's very, that only, it makes you think, just, your life, you have many opportunities and many challenges one should do. That's, I call lawyer plus.
definitely, sir. That's quite motivating that you do so much activities and you're like a north star for us. We look up to you, and all these activities are really inspiring and motivating. And we are also waiting for your books. We'll definitely like to read the book on the law. Yes, sir.
Okay, thank you, Jyoti.
Thank you, sir. And sir, the last question that I have for you, what would be your advice to all the younger members of the bar and also the students who are watching today and who are joined today with us? They will look up to you for motivation. What would be your advice, especially to the ones who are from first generation? They don't have any backing from any family member. What would be your advice, sir?
So my first advice would be, uh, you should never leave, your motivation to learn, and also, translate or convey your knowledge to others. That's the first thing. So you should learn, learning, and conveying the learning, because whether your knowledge you should be able to share to your client first, your brother in lawyers, then the judges, then the society. So that's what. So learning is very important for a lawyer. So learning needs discipline, hard work. So pursuit, single-minded pursuit. So any person, I have seen many, who are, they look very ordinary, came from very ordinary background, first generation. They even, they retired as high court judges, even Supreme Court, and very successful lawyers. So I think there is no limit to this profession, the challenges, the success. But you should never lose hope. You should always be confident. You should be courageous. You should know how to present your ways confidently, without fear of it. And finally, I always say, lawyer plus, be a lawyer plus. Can be in the politics, some are, many are there, but apart from that, social should never lose, your what service you can do the society. It's a very wonderful opportunity, scope for development, So but the thing is, you should be self confident and courageous, so that you can serve the society better than others.
Absolutely, sir. The vocation of a lawyer is something which is gives many independent facets to our life. We can do many more things than just appearing before courts. And you have done several things to motivate us. And especially the advices given by you will definitely be adhered by all the students who are watching us today. So with this, we have come to the end of this episode.
Okay, thank
Thank
you,
you for
Julian.
joining us, sir. Thank
Okay,
you, sir. We are really honored and privileged to have you today. We dealt with your childhood days, we dealt with your career, your early education, and how you joined this profession, how you conducted several cases, and how you were introduced to several new facets of law. And you have also given us several pointers and advices for effective practicing and advocacy. It was really an honor for us to learn all these things from you, a person who is a multifaceted person and who is really very inspiring and who always contributes to the society more than what is required. Thank you, sir. We are really inspired, honored, and privileged to have you this afternoon. We are really honored and we look forward to host you again in the future as well. Thank
okay,
you,
it's a
sir. Thank you
pleasure.
very much.
I really enjoyed, sharing my experience, my thoughts, and Debashish and Jody, are doing a wonderful job, and it will be a good opportunity to learn from, for us also for learning from you, for the students and audience to know, learn. Actually, life is that is all about. Thank you very much.
Thank,
All
Absolutely,
the
sir.
best.
thank you
Absolutely.
so much, sir.
Yeah, my best wishes for you.
Thank you, sir. We
We
wish you health. We wish you health
Oh,
and prosperity, sir. Thank you.
thank you, thank you, thank you.